Hello everyone, this is CA Radhika. I hope you are all doing great and well as well. In this session, we are going to discuss the part 3, the fundamental rights of the Indian Constitution, which is the most crucial and imperative part, which comprises of Article 12 to 35. We are not going to discuss entire articles in one slot or in one video. I am going to discuss today only 3 articles, article number 12, article number 13 and article number 14. After that, we are going to discuss the so on articles in next hour videos. Before starting the session, I would like to focus on this quote. This is a funny thing that the rule loving people is that to them it seems more important to impose punishment than it is actually solving the problems. But the most funniest thing as ever that the rule breaking people is that they seem to breaking rules is the easier to do if someone else has broken them first. So what I'm trying to say from this quote is that I want you to all to shift your perspective from a victim mind to a solution oriented person. Instead of finding solutions, we always try to blame our situation circumstances. So just focus on finding the solution because every problem has its own solution. Okay, now let's start the session. Okay, the part 3 contains article 12 to 35. In this session, I has already mentioned we are only discuss only 3 articles. So there are, first we need to understand what are rights. Rights है क्या? Rights are the claims which an individual claims against the state. Rights वो claims है जो हम एक state से मांगते हैं, अपने state इन जो government जो हम पे rule कर रहा है, the person who is ruling on us, we are claiming for us. Rights सबके पास है. All everybody has a right to live, right to sleep, right to work. Everybody has right, but they are only become considered as rights only when we are able to claim these rights. We have a property, but if I cannot claim on that property that is this belongs to me or somebody else do not claim that property that property is belong to someone else, then it is not a right, because rights are only the claims that we are going to be against the often claims against the state. जो वो सब हम state से लेते हैं, वही सिर्फ rights वही होते हैं. Okay, the origin of rights has been came from the Magna Carta. Way back in 1215, England was a monarchy. There was an absolute monarchy system was going on, where the law which is made by the king is considered to be the absolute law. The entire country works on the whims of the king. Whatever the king wants to do, he is do. It is a kind of autocracy or tyranny, you can say that. But it is the monarchy, yani hierarchical autocracy. So one day all the people or the individuals or the people of the territory revolted against and claim for their rights. So in that case, the Magna Carta 1215 has been issued, which has given the rights to the people of the England, which are there very essential for the purpose of living their own life को जीने के लिए बहुत ज़रूरी होते हैं, वो rights उन्हें दिए गए. There are different types of rights: the natural rights, fundamental rights, human rights, legal rights. Natural rights are wider rights which has been given to you once you are born. It is not given by anybody else or a state or a country. It has been come to you because of the nature, because of the existence. The you as being as an existence of a human being. आप human being हो तो इसलिए वो आपके पास natural rights है. That जैसे कि आपको you right to sleep है आपका, right to work, right to explore the things, right to extract the resources. These are the natural rights. But out of the few हम the being considered as a fundamental right, उसमें से कुछ rights को separate किया गया है, उन्हें fundamental rights कहते हैं, because these rights are the mentioned in the fundamental law of the land. उस एरिया के उस लैंड के वहाँ पे जो फंडामेंटल लॉज फॉलो होते हैं उसमें मेंशन है. दैट्स व्हाई दीज आर नोन एज फंडामेंटल राइट्स, बिकॉज दे आर बीन प्रोटेक्टेड एंड गारंटीड बाय द कॉन्स्टिट्यूशंस. कॉन्स्टिट्यूशन के द्वारा अगर आपको प्रोटेक्ट, दीज आर राइट्स आर नोन एज फंडामेंटल राइट्स. ओके, नेचुरल राइट्स आर वाइडर. फंडामेंटल राइट्स आर अ सबसेट ऑफ नेचुरल राइट्स. ह्यूमन राइट्स, that is very essential for the purpose of ensuring one's human dignity to being as a human. Legal rights, which has been stated or mentioned in the specific statutes, these are known as legal rights. Okay, I hope you understand the basic understanding of what are rights. Rights होते क्या हैं, राइट्स का ओरिजिन कहाँ से हुआ, टाइप्स ऑफ राइट्स क्या है. आई होप यू ऑल अंडरस्टैंड दिस, बिकॉज इफ we all have natural rights, but if we cannot be able to claim it, they are not considered to be as rights. Rights only be considered as rights when they can be claimed against anybody, then only we can consider them as rights. Okay, now as I told you why we call them as a fundamental rights, because these rights has been stated or mentioned in the constitution of the law of the land. That's why these are known as fundamental rights. They are justiciable, because you can go to the court that my right to work or right to sleep or right to life and liberty with dignity is being affected. You can go to the court and claim for the right and get the compensation regarding that as well. These are political rights. These are political, they are not social economic rights. Social economic rights we are going to be discussing in further articles, and these are the very essential or crucial aspects of being as a human existence. For example, the right to minority, regarding right to be profess, propagate your own religion, right to do any kind of profession you want, right to do work as well, that you are not be arrested arbitrarily. These are rights that is very essential part of your life being as a human existence. Okay, fundamental rights of India has been borrowed from two, that is USA, the USA United States of America का जो बिल ऑफ राइट्स है वहाँ जो फंडामेंटल राइट्स उनका जो बिल ऑफ राइट्स कहते हैं उन्हें, वहाँ पर फ्रॉम दे वी हैव borrowed few aspects of that, of many of the aspects from that, and most important the United Nations Declaration for Human Rights, on that we have borrowed the fundamental rights. Okay, so our fundamental rights has been borrowed from two, or we can say that because Indian constitution has been made from various after reading or understanding the deep depth understanding of all the constitution of India other countries that has been existed at that time. After that we made it, so fundamental rights has been came from these two, USA Bill of Rights and United Nations Declaration of Human Rights. Okay, now we are going to discuss the basic feature of fundamental rights. Okay, basic feature. Fundamental rights, they are available to citizens and foreigners as well, but few are the fundamental rights which only be available to the citizen, as we have already understand the concept of citizen and foreigners, or the enemy, alien, or the alien concept. So in the part 2 of the Indian Constitution Act, I hope you get that. So only I have already mentioned in that as well. Now I'm reminding you this article number 15, that the right to not to discriminate on the basis of your race, religion, caste, sex and gender. Another right, article number 16, that there is no kind of discrimination in getting an employment in the public offices. And article number 19, right to do any kind of profession. Article number 29 and 30, right to protect the minorities. These are only rights which has been given specifically and exclusively to the citizen. All the remaining rights are also given to the foreign service, but not the enemy aliens. Enemy aliens are those aliens or those people of the country of which India is at war. Okay, so they are available to citizens. Okay, I need to mention it, citizens and foreigners. Okay, they are not absolute right, they are should be qualified in nature. For example, in article 19, that they have one of the right to be freely movable in the territory of India, but you are not allowed to be moved into the territory of tribal areas with the proper permission and guidance. They are not arbitrary action of the state, not of the private individual as well. For example, article number 17, right to untouchability, abolition of untouchability. Either the state cannot do such kind of practices, or the private individuals cannot do such kind of practices as well. Both has been included in this. So say they are not only against the action of the state, state ऐसा नहीं कर सकता, that it cannot be abridge our rights or take away our fundamental rights. They are also be considered, private individuals cannot do as well. They can be positive character, they can be negative character. We will going to be discussing in article 15 and 16 what are the positive and negative characters. Okay, and the Supreme Court is the protector and the guarantor of the fundamental rights, because they are justiciable in nature. Okay, They are not sacrosanct or permanent. Any of the fundamental rights can be taken away or average away as on the conditions or the requirements के basis पर, and the respective laws in this respect has been made by the parliament in this behalf. For example, you can say that, for example, I am giving an example, Article 20 and 21 is going to be considered in national emergencies as well. We are going to discuss in the national emergency in the upcoming sessions as well. But Article 19 is being suspended while national emergency has been enforced in the country. Fundamental rights are restricted in the martial law. Fundamental rights are not to be available in the martial law, that we are going to be discussing in Article 33, 34 and 35. There are some exceptions of the fundamental rights as well there. They are directly enforceable. Some are rights you can directly enforce, but some require the enforceability by a proper statute formation in that respect made by the parliament in this behalf. For example, Article 21 is right to education. They will only be enforceable when the parliament has make rules and regulation and laws over that regarding the right to education. Article number 35 we are going to discuss this as well. Okay, I hope you understand all these concepts. What are rights, what from where they are origination, what from is issue, what are types of right, and what are the fundamental rights, and where we had borrowed it from, and what are the features of fundamental rights. I hope these all are the basic requirement to understand the further topic in this regard. So now we are going to discuss our main part. Now we are let's discuss. One of the thing I want to tell you. Okay, this part has been. We have total 7 fundamental rights, as I mentioned, as you can see on the screen. Right to equality from Article 14 to 18. Right to freedom, Article 19 to 22. Right against exploitation, Article 23 and 24. Right to freedom of religion, Article 25 to 28. Cultural and educational rights, that is minority rights, Article 29 and 30. And right to constitutional remedies, Article 30 to 35. There are total 6 rights has been given, but originally there were total 7 rights. Right to property under Article 31 has been also included, where originally at the time of the commencement of the constitution, but after 44 Constitutional Amendment Act, this right has been repealed. Now it is a legal right, and this right has been come under Article 300A Part 12. So now originally we have 7 fundamental rights, but now we have only 6 fundamentals. Okay, there can be an MCQ, so the right to property is a fundamental right or not. So it is not a fundamental right. Yes, there is one question you can arise over that right to property is a legal right or a fundamental right or a constitutional right. There is also a Supreme Court case over it. The right to property is a legal right or a statutory right, not a fundamental right. It is not a fundamental right. Okay, now we are going to discuss article number 12. Okay, Article 12 gives the definition of a state. कि state, the rights are the claims that we are going to be make against the state ना. तो what is state? State का क्या मतलब है? So it has been specified in the constitution that in this part, unless the context otherwise requires, the state includes government, parliament, government of India, parliament, the government and the legislature of each of the state, government of the state and the state legislatures, all are being included, and all local authorities as per the definition of General Clauses Act 1897 Section 3 and all other authorities within the territory of India, जितनी भी authority जो territory of India के अंदर आती हैं and under the control of the government of India के जो control में है, these are considered of fall the definition of the state की definition के अंदर होंगी. Okay, so what should the state comprises of? Government, central government, parliament, state governments and their legislatures along with the local and local authorities. Okay, all these are considered under the definition of a state. So I want so the question here is judiciary is under considered to be as a part of the state? क्या judiciary जो है उसे state का part माना जाएगा? It depend upon the case to case कि judiciary is a part or not. It depend upon the basis of the function is performed by the judiciary. Judiciary किस type के functions perform करके उसके basis पे we will consider it as judiciary is a part of a state or not. according to the case Naresh Sridhar Mirjakar and ORS versus State of Maharashtra, in which if judiciary is performing administrative or executive functions, then is considered to be as a part of the state. But if judiciary is functioning as a function as a judge or judicial functions, in that case judiciary is not considered to be the part of the state. I hope this question is been clear to you whether judiciary is a part or not. It is divided on the basis of the functions performed by judiciary, either administrative functions or judicial functions. Okay, now the question arises, is BCCI is a state or not? BCCI is not a state. BCCI is a state or not? BCCI is not a state because it is not been control or any kind of functions which has been under the control of the state. वो स्टेट के अंदर में नहीं है, किसी भी तरीके के स्टेट से कोई भी बाउंडेशंस नहीं है उसके ऊपर में, तो बीसीसीआई स्टेट का पार्ट नहीं है. आई होप इट इज क्लियर टू यू. Okay, now PSU is a part of a state. Yes, it is a part of the states. All other authorities, that is statutory or non-statutory authorities like LIC, ONGC, SAIL, GAIL, they are part of the state. According to Supreme Court, even a private body or agency can be a part of the state, but it can only if it is fall within the meaning of the Article 12. That is that within the territory of India, under the control में होना बहुत ज़रूरी है उसके. That is the word control. Government of India के अगर control में है, then it is be a part of the state. Okay, I hope Article 12 is being clear to all you. Now we are going to discuss Article 13, laws inconsistent with or in derogation of the fundamental rights. If any of the this heading says it, if any of the laws which are inconsistent or taking away or abridging the fundamental rights, so what should be done in that case? It is stated. Clause number 1, all the laws enforced in the territory of India immediately before the commencement, जितने भी laws हैं जो commencement से पहले हैं, इन so far अगर inconsistent है, then they are to be void, null and void declare कर दिए जाएंगे. The state, second clause क्या कह रहा है? The state shall not make any laws which takes away or abridge the right conferred by. State किसी भी तरीके के कोई भी laws नहीं बना सकती है जो कि abridge करे, takes away करे fundamental rights को. And any law in contravention to this clause to the extent of contravention, कोई भी अगर इस तरीके के laws बनाए जाएंगे, if there is any in contravention with this respect, then they are to be considered to be void. Clause number 3, what should be considered in the definition of law? Law की definition क्या है? Law includes any ordinance, any of the statute, order, bylaw, rule or regulation or notification, custom, usage having the territory of India in the force of the law. Law के अंदर सारे ordinances, bylaw, notifications, any rules, regulation, custom or usage which have been coming in the territory of India in force, they are considered to be the law. Law in force के अंदर क्या क्या include law passed or made by the legislature or other competent authority in the territory. कोई भी जो law pass कर दिया गया या made किया गया किसी legislature के द्वारा, in that case हमारी territory of India. Territory of India I have already told you. Article number 1, territory of India means the union, all of the states, the union territories, any of the acquired territory of the India are considered to be the part of the territory of India. Before the commencement of the constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operating either at all or particular. Law and force जो भी law pass किए गए, made किए गए legislature के द्वारा, even before the constitution के commencement से पहले, which has not been in kind of contravention किसी भी तरीके का नहीं होना चाहिए और inconsistency नहीं होनी चाहिए उन laws की भी, then they are considered to be the law in force. And clause number 4, nothing in this article shall apply to any amendment of the constitution made in article 368. Now let's discuss this clause because this is a very important clause. This has been added in the constitution after 24 constitutional amendment act 1971. So now discuss it. Here we are going to discuss it. Okay, सो इन शॉर्ट आर्टिकल 13 आपसे कह रहा है, क्लॉज नंबर 1 आपसे कह रहा है कि अगर कोई भी प्रीवियसली कॉन्स्टिट्यूशन के कमेंट से पहले कोई भी लॉज वगैरह थे उन्हें रिपील नहीं किया गया है और वो कंटिन्यू है अभी भी, इन दैट केस अगर वो किसी भी तरीके से इनकंसिस्टेंट है विद दिस प्रोविजंस के अकॉर्डिंग पार्ट 3 के, तो इन दैट केस दे शैल बी कंसीडर्ड वॉइड। क्लॉज नंबर 2 आपसे कह रहा है एक स्टेट किसी भी तरीके के लॉज रेगुलेशंस को पास नहीं कर सकती जो किसी भी तरीके से टेक्स अवे और अब्रिज कर रहे हो आपके फंडामेंटल राइट्स को। क्लॉज 3 में आपको लॉज के अंदर क्या क्या होगा, लॉज क्या है, it could be any paper which is some few things has been written that considered to be a law or not, that is has been specified in this clause number 3. And laws in force, what does the word law in force का मतलब क्या है उस चीज़ को भी एक्सप्लेन किया। आर्टिकल नंबर 4 stated that nothing in this constitution, कुछ भी अगर हम इन कॉन्स्टिट्यूशन में अमेंड कर रहे हैं आज इस आर्टिकल में, nothing in this article, इस आर्टिकल के आर्टिकल 13 में कुछ भी shall apply नहीं किया जाएगा to any of the amendment made in Article 368 of this constitution. So let's discuss with this. So Article 13 is a wider connotation because it considered all permanent laws as well, temporary laws as well, statutory instruments as well, and non-legislative sources as well. So the case is that I'm going to ask you one question, that if any kind of constitutional amendment, any change, constitutional amendment means any of the change has been made in the constitution itself, would it considered to be a law or not? So as per the case studies, it is said that the case number 1, Sajjan Singh case 1964, in that case Supreme Court said that any kind of constitutional amendment will not be fall within the category of the law. लॉ की जो कैटेगरी है, जो डिफाइंड डेफिनेशन है इन आर्टिकल 13, उसके अंदर सॉरी कॉन्स्टिट्यूशनल अमेंडमेंट कंसीडर नहीं किए गए हैं। ओके, तो इफ अगर कॉन्स्टिट्यूशनल अमेंडमेंट नहीं किया गया, इफ एनी काइंड ऑफ कॉन्स्टिट्यूशनल अमेंडमेंट इटसेल्फ इज मेड इन द कॉन्स्टिट्यूशन विच इज टेकिंग अवे और अब्रिजिंग द फंडामेंटल राइट्स, इट इज टोटली अलाउड, इट्स टोटली अलाउड टू यू ऑल। तो सो दैट द पर्सन हुज फंडामेंटल राइट्स हैज बीन, whose fundamental rights have been abridged or takes away, there is no case to that you can go to the court and claim that my fundamental rights has been abridged. After that, Golaknath case 1967, 3 years after that case, the Supreme Court said in this case, this constitutional amendment is considered to be the part of the law. That means the law definition word Article 13 is considered to comprises the word constitutional amendment itself. If any of the constitutional amendment is taken place or done in the constitution, that also be considered a law, and that in that case Article 13 actives if and the judicial review concept start uprising. In that case Supreme Court comes and the judiciary come as a protector or a guarantor of your fundamental rights. But what's the issue is that in that case 24 Constitutional Amendment Act has been done in the Constitution 1907. Nothing in this article, I have already told you, this line read it again, nothing in this article shall apply, कुछ भी इस आर्टिकल में जो भी लिखा है ना वो अप्लाई नहीं होगा टू एनी ऑफ द अमेंडमेंट। कोई भी अगर अमेंडमेंट हम आर्टिकल 368 में, तो कॉन्स्टिट्यूशनल अमेंडमेंट जो भी कॉन्स्टिट्यूशन में अगर किसी भी तरीके के अमेंडमेंट्स आपको करने होते दैट हैज बीन डन थ्रू द प्रोसेस एंड एस्टेब्लिश एंड द रूल्स एंड रेगुलेशन फॉर्म्ड इन आर्टिकल 368 में जो स्पेसिफाइड प्रोसीजर उसके अकॉर्डिंग किए जाते हैं। इन दैट केस तो अगर कुछ भी अगर इस आर्टिकल में शेल अप्लाई, नथिंग इन दिस आर्टिकल शेल अप्लाई, इस आर्टिकल में जो भी लिखा है वो कुछ भी अप्लाई नहीं होगा कोई भी अगर अमेंडमेंट हम उस कॉन्स्टिट्यूशन प्रोसेस के थ्रू करते हैं। नाउ द जुडिशरी इज दैट इज दिस थ्रू दिस वे दे कैन डू एनीथिंग। नाउ द इशू इज दैट because government has the upper hand by changing the constitution itself, because the parliament, only the parliament can change the constitution, nobody else can change the constitution. But now the Supreme Court said that yes, you can make or abridge or take away any of the fundamental rights as per the requirement or the needed, but do not affect the basic doctrine structure. Basic structure doctrine को आप किसी भी तरीके से affect नहीं करते। What is basic doctrine structure? People has asked कि Supreme Court to what is basic doctrine structure? Supreme Court said basic doctrine structure, that is justice, secularism, feature of judicial review, federal character, sovereignty and unity, freedom and dignity of the individual, rule of the law, independence. So there are n number of things in which are comprised in basic structure doctrine. Basic structure doctrine has not been defined anywhere in the constitution. It is the judicial creativity which has been come over the times, and this list goes and goes on the basis of the contemporary time. That's why we also call the Constitution of India is the living document, because it has been evolved over a period of time on the basis of the contemporary issues and contemporary needs and requirements of the people of the country. Okay, I hope you understand this clause 4, the importance of this clause. This is very crucial clause to understand because it is the most important one which has created the history, because the Keshavnanda Bharti case. That's why this basic structure and doctrine has been come in the Keshavnanda Bharti case in 1973. I hope you all understand this part. Article number 12, article number 13 has been clear, and specifically the clause number 4, which is very crucial because the same clause has been stated in article number 368 as well. Okay, we will make a separate video over this basic structure doctrine as well, but here we need to understand what is that is ki whether constitutional amendment is considered to be a part of the law or not. Because if it is not considered as a law, then then our fundamental rights can be abridged or taken away. If it is considered, then it is not being taken away easily. Okay, and under basic doctrine structure concept has been Supreme Court stated also that fundamental rights are a part of basic structure doctrine. They are not the entirely whole of the basic doctrine structure. There are other things as well in basic structure doctrine like secularism, sovereignty, unity, freedom, rule of law, independence of judiciary, judicial review, supremacy, justice, separation of powers. These are also part of the basic structure doctrine. Fundamental rights are a essence or a part of it. It is not the whole of it. Okay. And one more question I want to state, that whether judicial review can be done or not. Yes, in article 13 it is not itself mentioned कि judicial review can be done or not, but it has been provided the specific condition on that the state shall not be can be taken away or any abridge of your rights which has been conferred in this part, in part 3, that is fundamental rights के अंदर में. तो judicial review is crucial part because article 32 for the Supreme Court and article 226 for High Court, it's give this basic view about that is the doctrine of judicial review. Judicial review का जो concept है वो दोनों में mention है. There are 5 kinds of writs: habeas corpus, certiorari, quo warranto, prohibition, and one more I skipped that. Oh, okay, we will discuss in article 32 as well what are these writs and what are that. Okay, and the last one is quo warranto. Okay, now we are going to discuss about article number 14. Okay, article number 14, the state, that is the right to equality. We have given the first, we have studied right now, have been seen the image, that is there are total 6 rights. Now we are starting the right to equality, which comprises article number 14 to 18. Today we are only discuss the right to equality, article number 14. Okay, right to equality में सिर्फ article number 14 पढ़ेंगे आज, that is equality before the law. State shall not deny to any person equality before the law or equal protection of the law within the territory of India. Okay, what does it mean? State जो है किसी भी तरीके का डिनाई नहीं कर सकती किसी भी पर्सन को इक्वलिटी की. हम लॉ की रिच को अलग तरीके से ट्रीट करेंगे, पुअर को अलग तरीके से. इक्वलिटी बिफोर द लॉ. द सेकेंड कॉन्सेप्ट इज इक्वल प्रोटेक्शन ऑफ लॉ. सबको इक्वली प्रोटेक्ट किया जाएगा इस लॉस के द्वारा. किसमें? विद इन द टेरिटरी ऑफ इंडिया. टेरिटरी ऑफ इंडिया के अंदर में. नाउ लेट्स डिस्कस दिस. दिस इज द मोस्ट इंपॉर्टेंट टू अंडरस्टैंड द डिफरेंस बिटवीन दीज टू वर्ड्स. ओके, here it is, equality before the law and equal protection of the law. Equality before the law, it is a negative concept which has been come from the United States, England, which has been come from the England, or that is a part of the English common law का part है, that everyone should be treated equally, that everyone should be treated equally before the law. There is no should be a difference between a rich and poor, white and a black, or a man and a woman. There should not be any kind of difference in this. And this is merely a general concept. It focuses on the rule of law, that everybody should be under the rule of law. Who has the upper hand? Only the laws. Laws has only the upper hand. Nobody can do anything against the laws. Absence of special privilege, that everybody should be treated equally. Rich and poor all are equal treated. That rich get the rights of the that he can hire a legal representative for himself or herself, that the poor can also hire the legal representative for himself or herself. If the rich can be protected against the preventive detection or arrest, in that case the poor also giving the same kinds of rights. But the point is that it may be the case that poor know the rights but doesn't have that economic political rights. in that case उसके पास इकोनॉमिक राइट्स ना हो उन चीज़ों को अवेल करने के, उसके पास राइट्स हो. तो फॉर दिस पर्पस इंडियन कॉन्स्टिट्यूशन हैज़ बीन गिवन इट द वाइडर कॉनोटेशन इन दैट्स इक्वल प्रोटेक्शन ऑफ लॉ ऑज बीन also incorporated in our this, that is a positive concept which is a very specific. It allows a reasonable classification that has been taken from the American Constitution, or it is an American constitution that will allow the reasonable classification that is called based on intelligible differential and substantive distinction. What does it mean? It says that if somebody requires help, in that case we are providing the special privileges to them. For example, woman does not have any kind of rights, and their rights has been violated since ancient times. So in modern times, to make them parallel or getting their representations in every field in compared to the percentage of the man, so we are giving the special protection to them. Same goes with the scheduled caste and scheduled tribes. We have given the special privileges to them in the public offices, in representation purposes, in various kind of benefits in that. So that is allowed. In juvenile cases, those who are teenagers, if they have been done something criminal, then in that case we are not punishing them as an adult. We had to as an adult, but we are giving them some kind of relaxation in that. So it is said that no, everybody should not be equally treated. Equals must be treated equally, but unequals must be treated unequally. जो unequal और unequal, जैसे for example I have given the example of the women, juveniles, scheduled caste and scheduled tribes. This is the basic. So Article 14 of Indian Constitution is a wider connotation. It is not only to the rule of law or absence of special privileges on the negative. It is a positive connotation as well. Okay. And within the territory of India, the word territory of India includes the Indian embassies as well, which is located outside India. If any of the person whose rights has been violated over there, he can claim. As we had already read the preamble of the Constitution, in which has mentioned equality of status and opportunity, because it gives equal status to each and everyone. Then rich and poor all are treated equally. If everybody has equal rights. For example, those who are 18 plus, they get the right to vote. They all have political rights, irrespective of their financial background, their gender, their religion, their caste, irrespective of their decency, whatever is their decence, irrespective of their residence. We have given all to the equal political rights. So we have given the all equal status. In the front of judge, rich or poor treated similarly for a same crime, for a same mistakes के लिए. And everybody has given the equal opportunity as well. Everybody has been given the equal opportunity to pursue their own passion, profession, their skills, their abilities. Everybody has given the chance to untap their potential. So Article 14, it's not about the equality before the law. It is all about the equal protection of the law and giving the equality of status and opportunity as well. Okay. Now, there are certain exceptions to this. Okay, just give me a second. Now you need to understand the word rule of law, which I mentioned it here. What does it mean? Rule of law, it means there is an absence of arbitrary power. Arbitrary में कोई भी आएगा कुछ भी कर देगा, ऐसा नहीं. There are certain rules and procedures which should have been followed. For example, if the PM and the Council of Ministers should have been followed the procedure which has been stated in the Constitution, उन्हें उसी के according काम करना पड़ेगा. That has been followed the specific procedure, specific rules and regulations के तहत ही आपको काम करना होगा. That is, there should not be an absence of power. No person can be, for example, no person can be randomly punished for anything or anything else. There should be a proper rules and regulation on that behalf the person should be punished. Okay. Second, equality before the law, as I already mentioned, that everybody is treated equally. Even it is not about only rich and poor, even the MPs and MLAs and the people or the grassroots people are also being treated equally. There is no distinction that they have been exception to the crime or a murder, but the local people do not have. They should not be like this. Equal, everybody is treated equally for their mistakes and their crimes. What is most important in this? The primacy of the rights of an individual should be protected and given. This is the rule of law, and there are certain exceptions to Article 14, that is an Article 361. It is about the immunity to the president and governor while they are working in their office regarding the criminal proceedings के regarding में है कि जब office and president और governor they are working in their office, तो कोई criminal proceeding उनके ऊपर initiate हो चुकी है, already ongoing है, तो in that case में they have given us some kind of immunity. So Article 14 is not being applicable into that. नेक्स्ट इज आर्टिकल 361A, प्रोटेक्शन एंड प्रोसीडिंग. कोई भी पार्लियामेंट स्टेट लेजिस्लेचर्स के थ्रू किसी भी तरीके के पब्लिकेशन से प्रोसीडिंग्स निकाली गई हैं, तो इन दैट केस में दे आर ऑल्सो बीइंग इम्यून टू इन दैट रेस्पेक्ट इन एनी काइंड ऑफ issues can be arise over that. Article 105 for the parliament and article 194 for the state. Powers and privileges in the house of the parliament and members. That की house की privileges of the house होती है, जो भी MP MLAs हैं, they have their respective privileges in the house, that they can speak anything. They cannot be sued for the documents and whatever they speak in that house. Okay, there's the diplomatic immunity as well. If any of the foreign diplomats come and say something or do something like that, that have been a specific protection to that. For example, if a diplomat come and his car just got stuck or hit the man on the road, in that case diplomat given the immunity because he is a foreign national, not an Indian. Military courts have their own rules and regulations, so right to equality that not been applicable on that. And there is a special court as well. Example, ED offices, PMLA Act. They have अपने certain rules and regulation है. We are going to discuss in Article 22. In that, the right to self-incrimination, that if you are giving the witnesses against yourself, then you are not to be considered as a witness in any of the normal laws. But in PMLA, it will be considered as that your self-incrimination will be considered you as a witness of it yourself. We are going to discuss in that as well. So I hope you understand all those exceptions. Article 361, 361A and 105, 194, diplomatic immunity, military courts for armed forces and special courts. Okay. So this is for the today. I hope you get the understanding of all three articles 12, 13 and 14. Have a good day. We are going to discuss article 15 in our next video. It's going a comprehensive article. So